welcome to Mutually Speaking by Navy Mutual. We are dedicated to educating military service members and their families on matters of financial security. The Navy Mutual Aid Association Mutually Speaking podcast is intended for general informational purposes only, as individual situations may vary. Statements made should not be relied upon as recommendations, solicitations, or construed as legal or tax advice. This podcast is not meant to replace the services of a licensed financial planner, insurance counselor, or tax advisor. Programs mentioned and other information referenced in this podcast may change from time to time. If you have questions or comments, or if there's a topic you'd like to learn more about on this podcast, contact us at podcast@navymutual.org. This season, we are focusing on retirement and long-term financial planning. Today's topic is estate planning. Many families spend a lot of time navigating paperwork and lawyers after the death of a loved one, but the process, which is already hard enough without any added stress, can be made easier if you plan ahead. In this episode, we'll go over your objectives for estate planning and then talk about documents, taxes, wills, probate, and trusts. Here to speak with us today is retired Rear Admiral Brian Luther, CEO of Navy Mutual. Thank you for joining us, Brian.
I'm excited to dive into this important topic, Kate.
I'd imagine that estate planning is sometimes a hard topic to talk about. People don't really like to think about, what might happen after they pass on because it gets them thinking about, death, and no one really likes going down that road.
I agree. You're right. People don't like to face the fact of life that at some point their life will come to an end. But it's important that they do, though. Planning for what should happen if you were to die or become incapacitated ensures that your wishes will be followed in the future. And if you don't have a plan in place, you have no say over what happens to your asset and your family, and in some cases, your own medical care.
So what exactly is estate planning then? Is that only something for, people who are wealthier, or is that, who is that for?
No, it's not a rich person thing. It's a person who owns things. So if you own assets like a house or cars, if you have money saved in savings or in retirement accounts, or even if you have debt, because your debt will need to be settled, your estate will settle that debt. And so you need to have a plan in place for how the estate is handled when you pass, so that things that you want to go to your loved ones go to your loved ones, and things that should be adjudicated and resolved by your estate are properly handled.
And what do people need to do to make sure they're covered in the future?
Well, as I've said in the previous podcast, it starts with a plan. So estate planning is essentially the process of deciding what to do with your estate upon your incapacitation or death. So it'll involve figuring out who gets your belongings, where does the money go, and that's what most people think of, the reading of the will in the movies and the TV shows in the library, and the kids getting upset because they didn't get this. But people want to take care of their kids. They want to take care of pets. And as I mentioned earlier, you should have a plan for yourself if you're incapacitated. So you want to do things while you're alive, so that that the family doesn't have that stress of making decisions or trying to figure out what you wanted after you pass. So you're trying to make the process move smoothly for your family after you pass.
Sure. And that sounds simple, but I'm guessing it's a little bit more complicated.
Yes and no. Well begun is half done. So if you get all your documents in order, that's half the battle, if everything is all in one place. And then you'd want to go to a lawyer who's familiar with estate planning. And then after that, it's just a puzzle for you to figure out on who gets what and what you want your legacy to be. But you need to examine that and make that decision.
And how do you get started with all that?
Well, there's generally two sets of objectives for estate planning. those that you do when you're alive, and those you expect to be done by your executor, someone else after
Mhm.
you pass. So while you're alive, your job is to document your intentions, transfer the assets to people or trusts, or some married people making your accounts joint accounts, right?
Mhm.
So that when you pass, it's a joint account. The spouse automatically has access. You should decide who is going to be a guardian to care for your children if you're incapacitated, or make a guardian, appoint a guardian to make financial decisions for you if you're incapacitated. So there's multiple scenarios, but everything you do now provides peace of mind for the future.
And what are the objectives for after your passing?
So you want to have in writing directions how to appoint a guardian to care for any children who can't live on their own, how to distribute your assets, when to distribute it, to whom you choose. If you have a charity you want to support, provide charitable gifts to organizations. You want to minimize potential expenses. You want to minimize taxes. You want to avoid any legal or financial complications. You want to avoid family disputes. Anything with paperwork has delays, so any work you do ahead of time will eliminate delays. You want to take a look at your business interests if you have a family business or anything, and then you should have a succession plan, and that plan should be in place. Um, and then you'll add, when all that's done, you'll get to that part of the reading of the will, if you will, and that would be the who gets what and when.
Right. And that's the part of the estate planning process that people are most familiar with, like you said. But I do want to backtrack just a little bit. You've mentioned that you need to have plans in place for your potential incapacitation. Could you expand on what that means a little bit?
Sure. Unfortunately, not all of us are going to pass away peacefully
Mm.
with full use of our faculties. So, as people age, degenerative disorders may become more severe. People could get Alzheimer's, dementia, lose the ability to live on their own and have to live in an assisted care facility, or they may need help with basic life activities like eating or breathing, and you might need some at-home care even if you're not in an assisted facility. So you need to have a plan in place for these possibilities, because if you become incapacitated or you can't make a decision for yourself and you haven't prepared documents to say this is my wishes or intents, then those decisions will be made for you by a person appointed by the court, or a civil bureaucracy that says by law we need to take care of this person.
Mm.
And so it's important to have those various forms on file and to share your decisions with your family, other named person that you may trust, or your doctors, so that your wishes will be fulfilled.
So if you don't have the right paperwork, your care is sort of in the hands of the legal system potentially.
Right, which is why there are so many various documents that everyone should consider as part of their estate plan.
And what are those documents?
So there's four big ones. The first one is a durable power of attorney, and it's a legal document where you're appointing a person or persons that you want to make financial decisions for you. And for those who've gone on deployment, they're probably familiar with the power of attorney. And so you go on deployment, you give your spouse the power of attorney, and so they don't have to mother may I you from halfway across the room. They just handle it right there because they have your power of attorney and they're represented. So, just as with a deployment, you specify the powers being granted, when the document becomes effective, if there's a sunset, when the document is no longer valid. So, like for deployments, they were often done for the length of a planned deployment. Then there's a healthcare proxy. Sometimes that's called a medical power of attorney. It appoints a person to be your healthcare agent and to make healthcare related decisions for you if you're unable to do so. And it also serves as a direction for the appointed person, or to limit the healthcare agent's power. And that's not limited to end of life treatment, but it also includes routine medical care. And this is important because if you're incapacitated, there are family stories where the person's intent was to pass, and they didn't have a do not resuscitate, and so the family couldn't let them pass, and so they got into an extended hospital stay against the wishes of the individual. So,
Sure.
and so you have to understand, and when you appoint that person to make healthcare related decisions for you, that they're willing to make those healthcare relations. It's a deliberate conversation you need to have with that person.
Yeah, and it's a large responsibility too.
It is.
So a lot of people have those end of life care, and whether or not they want, just like you were talking about, so whether or not they want to remain on life support or coma.
So you have your health care, and then you have your living will, and that living will documents your wishes about being kept alive in the case of terminal illness, or coma, persistent unconsciousness. You specify the treatments that you would and would not accept in a situation. So it's an escalation of care and decision making that you're empowering people by each one of these documents.
Sure. And then what was that last, the fourth document you mentioned?
It's a little less well known, but I was referring to a declaration of an anatomical gift form, which allows, if you'd like to donate your organs for transplant or you donate your body for medical research.
So it's not enough to say that you're an organ donor, like on your driver's license?
Yeah, they're a little bit different. So a designation on your driver's license only signs you up for organ donation.
Okay.
But if you wanted to donate your body to science, that would need to be written out separately, right? Because often the organ donor on your driver's license card is something happens as a result of an accident.
Sure.
This is a planned and deliberate decision on your part that you would want executed after your passing.
Yeah, that makes sense. So we've talked about these documents that help plan for incapacitation, but are there other documents that are important?
With the military, there's always more paperwork. So if you want access to burial benefits or to ensure your family can access your survivor benefits, you need to make sure that you have a copy of your DD 214 and any disability information indicating the benefits filed in a well-known location. And when you retired, you should have gotten multiple copies of your DD 214 that were notarized or certified as true copies, because your survivors, people are going to ask for a copy of the DD 214 to be provided to get some of this, and they're going to want that certified true copy. So you need to have multiple copies of that ready so that they can hand them out to the VA or the various entities that are saying, hey, we need something. So if you only have one, then that will cause a delay as you go and get a certified true copy of it. But generally, the personnel support department or equivalent for the services when you retired gave you multiple copies.
Great. And then speaking of documents and filing them away, where should people be filing these away?
Well, another great question. Location is often an overlooked issue. It has to be someplace that your survivors can get to, right? They need to know where it is. And you should have all your estate planning documents in there. That needs to be a conversation. Maybe you put a fireproof box somewhere in the house or a filing cabinet. You can go old school and put them in Tupperware, put it in the fridge. If you're going to get like a small safe fireproof box or something, make sure that it's mounted to the floor, because if you put all your documents with all the personal information with something that is easily transportable, if a thief comes in and finds a safe and they pick up a safe, they'll take that safe and open it up at their leisure. And then now you have all of your documents, your entire estate, and everything is available for someone to take a look at. So if you want to do it at home, just make sure that you have something that is not individually transportable or mounted on the floor. If you don't want to worry about that, at Navy Mutual, we offer our members free storage of their documents in our vault. And so as long as your family knows that it's in the vault, they'll be able to come and use them. Without these documents, it'll be harder for your family to follow your wishes, both because they don't know and because it provides them legal options by having those documents in hand.
Sure. And then, mitigating the delays again, if the documents aren't readily available, that's another delay.
That's another delay, yep.
Yeah. So it sounds like I need to have a conversation with my family.
It's always a good idea to be prepared for the future.
So I do think, though, that there's an elephant in the room. We've talked about medical directive forms and making sure that military files are accessible for benefits purposes, but we haven't talked about the biggest estate planning document that there is, the will.
Right. So the will is the document when it comes to estate planning in the traditional sense, because it provides instructions for the distribution of your estate upon your death, and it appoints a person to administer your estate. So somebody you choose the executor, right? Mm-hmm. But it's somebody you clearly that you trust, and they will be running the show after you pass.
Right.
So a will alone, though, does not create the most effective estate plan, and we'll get into this later. But it does give you that ability to select your executor, and then it will give them the instructions to indicate, this is who I want to get what. In my personal, I have identified watches that I've bought for myself, but each son will get a special watch, right? Oh. And then, but I have more watches than sons, so there are other people that will get it. If you have a lot of money and your kids are young, maybe you want to provide limitations about when and how assets will be distributed, right? Mm-hmm. Maybe you want to say, hey, give them it when they're 30, or give them it when they're 36, so they get started in life on their own 2 feet and they have it. And we mentioned this earlier, right? If you have minors, you want to have a guardian, and you should have a conversation with the guardian about, hey, this is, how will my kids live under your roof? And do you need me to provide something to, put an addition on your house or to do something? And if you have special needs, are you willing to accept a child with special needs, and what do you need to support that kid? And then that will allow you to specify assets to be transferred, to maybe a medical trust or some other trust upon your death. And then it also submits that your estate will be entered into probate, and then the administration of your estate will be supervised by a court. So that's part of a will, because now your instructions for your estate are being administered and observed by a legal entity, right? When you go into probate.
Sure. Yeah. And that is a tough decision too for parents, myself included, as you're the parent, right? That no one's ever going to replace you in your child's life, and they're never going to be as good as of a parent to your kid as you were.
Right.
But by not having a will, you're eliminating your ability to make that decision entirely.
Right.
Yeah. So a lot of good reasons for writing a will.
Absolutely. And it's a great place to start for the average person. And then while you're talking to the lawyer as you're doing your will, right? Or if you're going to the legal support office, wherever they do, it helps you, when we're talking about these documents, think through and figure out what other things you might need to do. But the will isn't the end all be all. There are a few disadvantages. I mentioned that you would be under probate, and wills are subject to probate, and there are associated costs with being in probate. And one of them is to determine if your will is valid or not. Mm. Right. So your will can be challenged. Creditors can make claims on your estate for any money that is outstanding. The key point is all information about your assets will be available to the public. So that's not necessarily a bad thing, but you want to weigh the pros and cons of that publicity, and know that your assets won't be available to your heirs until your estate is approved by the probate court. And generically, this can be 6 months and as long as 2 years. And when everything becomes public, there are some people that will see that and look at the size of your estate and then contact your family to help. And not all of them are altruistic, and they're more interested in helping themselves to your estate than helping your heirs get to your estate. So having it clearly documented helps.
Yeah.
And protects.
So even though a will is a legal document, it's still up to the court to certify that it's valid. And then on top of that, the will becomes public and can take a significant amount of time for it to be validated.
That's right. And, that's all about probate. So do you understand what I mean when I say, hey, it's going into probate?
I definitely do not understand what probate means.
Okay. So probate is a state legal process. And through that process, they identify the value of what you own and distributes the assets following your death. And so if you don't have a will, it falls to the court to assess your value, assess your debts, and then the assets subject to probate will then be distributed according to state law, right?
Mm-hmm.
But if you do have one, the probate court will supervise the execution of your will's instructions.
So it's sort of a fail-safe for people who pass without having written a will?
Right. Mostly because it's ollie, all in free on an estate. People can come in and purport to have a debt owed by the state. This is where if you have all your paperwork aside and say, hey, here's my accounts, here's this, it helps in the documentation. So it is, like you said, a fail-safe for those who pass without having a written will. And there are advantages to the process aside from, what you mentioned. You get the court supervision to ensure your executor is acting according to your will. It will put a time limit on how long the will can be challenged. It will limit the creditor's claims on your estate. It'll ensure your debts do get paid. There's always taxes, and so it'll handle your taxes. It'll settle disputes. It'll transfer legal titles, and so for those who aren't familiar with that whole process, it makes the process a lot simpler.
And what would be the downsides?
So nobody does it for free. So probate-related fees and expenses can range from 3 to 8% of the value of the estate, and that can add up. There's also what we mentioned before, assets subject to probate may not be available to your beneficiaries or the heir during the whole probate period. And so if there was an emergent need, they wouldn't be able to react to that until it's all done. And as I mentioned, all your assets will become public knowledge.
And are there ways to avoid it?
There are. But there are pros and cons to that as well. So most people want to transfer assets outside of probate so that you avoid that expense, you avoid the publicity, and you don't put that time limitation on. So again, as part of your financial plan, because there's always a plan, this may involve you may gifts while you're still alive, and then that gives you the opportunity to experience the joy of your recipient receiving your gift. It will reduce it by gifting while you're alive. It reduces the size of your estate, and so the estate taxes that you may have to pay. But if you are gifting an appreciating asset while you're alive, you're going to lose the potential appreciation of that asset. If it was a big dividend paying stock, or you lose the income from that gifted asset. And once you gift it to somebody, it's theirs. So you no longer control how or when the gifted asset will be used because it's not yours anymore. And if you get your timing wrong, gifts made within 3 years of your death may be considered part of your estate for tax purposes, right? So if you got bad news from the doctor and you start giving everything away,
sure,
the tax man knows that, hey, they probably knew the jig was up, and so they're looking for actions that are purposefully used to reduce your taxes.
So it definitely sounds like we're going to have to discuss taxes again. I think we've touched on taxes in each one of the episodes.
Death and taxes, right?
Yeah.
There's two things that are certain. So, and again, right, you should have a tax plan as part of your financial plan. So, and then in your estate plan, you want to minimize taxes, right? Because the taxes that is taking money out of the estate that could prevent your spouse from maintaining the standard of living that you had planned, right? So just like you want to plan your distributions, because your distributions from a Roth or a traditional, right, that has tax implications. You want to understand how your passing will have tax implications, right? So that you are getting the maximum amount of your assets transferred to your beneficiaries, and then you want to take care of your tax plan because you don't want to create a tax burden. So now your heirs have to borrow money or sell assets to pay the taxes. So you don't want to pass and create a problem, right? So you want to think all these things through and say, okay, here's what I want you to do, and then if they get a tax bill and the tax man saying pay now and probate saying like it's going to be 2 years, they're gonna have to pay the taxes.
So everyone's looking to maximize the size of their estate and ensure they're leaving their heirs as much as they can.
I think that's a reasonable assumption for the game of life. Yes.
And I would assume though that when it comes to estate taxes, it's not really the same process as filing your income taxes.
Right, because people pass at any time during the year, right? So the good news is it's not an immediate thing, right? So an average probate is 6 months. They understand that it's going to take some time to get through probate, but the taxes will be due 9 months after your death, right? You can do it earlier, but most people tend to keep the money on hand for as long as they can. But after 9 months, the taxes are due. So if you're in that 2-year probate and you have a tax bill, you're in there's a problem.
Sure. So, and what kind of taxes is it?
Well, like you're saying, if you earn money that year, they're going to want their income tax.
Sure.
So you're going to have to file an income tax. Income that you earned in the year of your death, income earned by your estate after your death, but before your assets were distributed, right?
Okay.
And there's a form, income in respect of a decedent, which includes any pre-tax contributions or tax-deferred earnings that you might have gotten from your IRA or your Roth, 401k, any kind of retirement plan, or if you had a tax-deferred annuity, for example.
Sure.
So they cast a wide net to say any form of income that you would have gotten from any source, document it so we can get our taxes on it.
Yeah, so that sounds fairly standard.
Right. But that's the simple part. There's capital gains tax, there's transfer taxes, and then once they have decided the value of your estate, then there's estate taxes.
So what would be the capital gains tax?
So capital gains taxes come into play when you're transferring appreciated assets, right? So the amount of taxes will differ depending on whether you gift an asset during your lifetime or whether you leave them to your heirs in your will.
How so?
Well, when you give an appreciated assets prior to death, the person who receives the gift can choose to sell it later, and then they will own capital gains on the entire the amount of the increase in value between what was originally paid and the sales price, right? So so they take, it's called the basis, right? So if you gift them stock, they take your basis, and then when they sell them, the value between that is capital gains. But if you inherit those assets, their basis is stepped up, meaning your heirs will own capital gains taxes on the increase in the asset value from the time they inherited it, not the time you bought it, but the time they inherited until the time the asset is sold. So if you have stock that you bought a long time ago and it's split, and so the cost per share has gone down and down and down, if you gift that to them, there's a hefty capital gains. But if they inherited it and the price is $10 that day and they sold it when it's $15, they're only paying $5. But if the split occurred and your price was $1, they'd be paying $14 in capital gains. So again, this is the importance of having good documentation, because that if you gift it, they're going to need to know that information. But if you pass, it just goes from the date that they got it from the inheritance.
So to maximize capital gains taxes for your heirs, it's important to leave them their money or stocks or, whatever type of account that is in your will, and not give it to them as a gift ahead of time.
Right. I know my kids will always take a gift of money. So you could have a stock that you recently bought that you think is a good long-term investment. So if you give them a stock at close to the time of purchase,
Mm-hmm.
right, and then say, here you go, then that the capital gains bite is small, right?
Sure.
So it's more if it's you would examine what the basis is at the time of giving. So it's kind of a depends, but your general statement is correct, right? If there's a large capital gains to be paid, you want that to be an inheritable asset.
Sure, that makes sense. And then what's transfer taxes?
So transfer taxes are a tax that you pay when a property transfers hands, and I don't mean just physical property, but bonds, stocks, and real estate.
Okay, got it.
And a gift tax is another tax, and that may be owed if you give money or assets to someone without receiving fair compensation. So I gave you $15,000 just for doing it. Well, so that's a gift then if I didn't get anything in compensation.
Mm-hmm.
But gift tax is only owed if you go above both the annual limit for a recipient. So that's why I use $15,000.
Mm-hmm.
That's the annual limit. Or if you gave someone more than $11,580,000 over their lifetime, which is the current lifetime gift exemption. So for most people, it's you give $15,000. That's
Mm-hmm.
the limit. People aren't worried about a lifetime $11 million. You probably have a guy for that if that's your problem. But gifts that are given to a charity or a spouse are often exempt from this tax.
Sure. So if say my grandmother gives me $15,000 a year for the next 5 years, there won't be any gift taxes imposed because she's stayed within the annual limit, and isn't anywhere near gifting me $11 million.
Yeah.
I mean, I'd still take it,
right.
but
that's right. But there's also there's a tax for everything. So there's the generation skipping transfer tax, and that is a federal transfer tax that may be imposed on a gift or an inheritance to persons at least 2 generations younger than the person making the transfer. But this tax also has an exemption, which under the current law is equal to that 11.58 million.
Got it. So it would have to be the grandmother situation would have to be giving away over 11 million before it's taxed.
Right, and provided she didn't exceed the $15,000 annual limit to any one individual.
Okay, and then finally with the estate taxes.
So estate tax, this is where things, if it wasn't complicated before, this is where it could get a little complicated. So first, there's a federal estate tax, and this may be placed upon your estate at the time of death based on the value of your taxable estate. So assets left to a charity or a spouse are exempt, though, from that.
And how would I know the value of my taxable estate?
So what will be done is all the assets of your estate will be added up using a fair market value, and that will determine the gross estate value. And assets include things owned solely in your name, or half of those owned jointly with your spouse, your percentage of assets that you own jointly with anyone else, if you had a percentage of a business, assets that were in a revocable trust, or any custodial accounts. And that's an account that you created in which you're a trustee or a custodian. Debts owed to you, so it's not, if people owed you money, that's considered an asset, and so that would be rolled in. Life insurance death benefits if the policy is owned in your name. So if
Mm.
your spouse owned the policy on you, that would not count as an asset.
Okay.
But if you're the owner of a policy on yourself, then your insurance,
Because the money went to
to
you.
you, so it
Got
becomes
it.
part of your survivor income benefits, annuity death benefits, and the value of your retirement plan.
So adding up anything that you have a financial interest in.
Correct, right? And then what you'll do is you'll add up your estate's liabilities, right, and the expenses that are ongoing to determine your allowable deductions. So liabilities and then expenses include the taxes you owed, any outstanding debts that you have, any settlement costs for your estate, any funeral expenses, gifts that you want to give to a charitable organization. Like I said, assets left to your spouse, and life insurance if the estate is the beneficiary.
Okay. And then what would be the next step?
So then, it's just a math problem at this point. So you subtract your liabilities from your gross estate assets to determine the value of your taxable estate.
And then once you know the value of your estate, you'll be able to determine what, if any, estate taxes you owe.
Yep. So it's either going to be a table or a percentage, and
Sure.
and then pay the man.
And does everyone have to pay estate taxes?
No, there's not everyone. So there's something called the estate tax applicable exclusion amount. And so this is the value of the taxable estate that can pass free of transfer taxes.
Mm.
And we mentioned this before. So in 2020, it was 11.58 million. Additionally, there's the concept of portability, and that was a result of a 2010 law. And it got extended indefinitely in 2012. And what that does is it allows the surviving spouse to take advantage of an unused portion of estate tax applicable exclusion amount of their predeceased spouse. And what this does is it provides a surviving spouse with a larger exclusion. But this rule is really for the wealthier of people, right? So if you sit there and you have a portion that I didn't use for my passing for my estate, then that would roll to my wife. But if I didn't have a really big estate, I didn't even get to the threshold, so it won't be a problem. So this is the wealthiest, 1-2% of Americans who pay these kind of taxes, where this would be a factor.
Sure, and that would be federal. And then would it go to individual states as well?
Yeah, good question. Many states have inheritance or estate taxes that are owed in addition to federal tax. State rules, states being states, the rules and rates vary greatly and may or may not follow federal program. So this is one of your considerations for your final retirement location, right?
Sure.
So you're looking at, do they tax my military retirement? Do they tax my Social Security? Do they have an estate tax? All factors to consider for when you're retiring. And so when you're talking to your attorney and your financial planners, they can give you, advice on that.
Yeah, it seems like a lot of estate planning involves talking to a lawyer, between writing out your powers of attorney, your will, figuring out your tax situation.
It's a process for sure, but, we saw it's a complicated one, right? And so hiring an expert will grant you that peace of mind.
Sure.
If you want to be sure your wishes are being followed after your passing. So it's the planning, not the plan. So it's worth putting the time and effort into doing it right from the start.
Definitely. So I have a couple other questions, though. We talked about drafting a will earlier and how a lot of people want to avoid probate, and that you can do that by transferring assets to people outside of your will. Could you expand a little more on that?
Sure. The simplest way to transfer assets to people outside of the will is to name them as the beneficiary to some sort of policy or account, right? So if they're the beneficiary, they will automatically receive the asset upon your death. So it'll avoid probate completely. But the system being what it is, not everything has a beneficiary designation available. All assets don't have it. So there are some things you can designate a beneficiary and some things you can't. So
Sure.
you have to understand what those are.
And when can it be used?
So their use of beneficiaries designated, for example, for life insurance policies, for annuities, for your retirement accounts, your IRA and your Roth IRA, your TSP, your 401k, or any other type of retirement plan. And I point out it's important to know that your surviving spouse has rights to a TSP or 401k, regardless of the named beneficiary, unless your spouse has waived all rights to the account, and that would need to be done in writing and notarized. So the spouse knows and is acknowledging that you are taking this, joint common account and giving it to somebody else, right?
Sure.
It's kind of like survivor benefit plan. The only way that you can take your spouse off is if your spouse acknowledges that you're not electing this benefit.
Sure. And I'd imagine, though, that it's important to revisit your beneficiary designations on a somewhat regular basis.
Sure. We're talking about passing, but if you identify a beneficiary and then the beneficiary passes, predeceases you, then you've created a do loop in the process.
Sure.
Because now they're looking to have it go to a beneficiary, and then they'll say, oh, now we have to adjudicate this, and then now it becomes part of the estate.
Sure.
And so the whole intent of what you were trying to do is lost, and it's going to roll back into your estate. So anytime there's a change in your life, a life qualifying event, right, that you hear and see all the time with your benefits at work or anything, you want to double check the beneficiary of your accounts. You want to ensure that the money or whatever the asset is passing to who you want it to go to. It's always a good idea to let the beneficiaries know, right? So people like that winning the lottery feeling. But if it doesn't show up, that's a check on the system, right? If you own a life insurance policy and pass away, and none of your loved ones file a claim with the insurance company because they didn't know about it, that policy and death benefit could sit unclaimed. Now the companies do death audits, and then they will look for.
Sure. So
they say, hey, this person passed, but if they can't find the beneficiary, if they can't find somebody to give that money to over a period of time, eventually the state will come in and say, since this is an unawarded, you don't get to keep an insurance company. It will go to the benefit of the state. So like in Navy Mutual, we will actively work to try and find those beneficiaries, any beneficiaries, right? But if we can't find them, the state will come and knock in, and we'll have to give that money to the state.
Right. And then it's, again, the whole point was to,
take care of your beneficiary heirs, your kids.
Right. What about with your everyday checking accounts or similar financial accounts like that?
So I mentioned before, you can make them joint with your wife. My wife and our accounts are completely commingled. So she has access. If I died, she has access to everything. But you can label bank accounts, CDs, mutual fund accounts, and brokerable accounts as payable on death accounts. And so this means that the ownership of an asset would pass automatically to the person you name without the risks of joint ownership, right? So if you don't want to be like me and have everything joint, you can say, it's all mine. I keep in, if you're in the things are separate, but upon my death, it'll automatically pass. And both options will avoid the probate.
Great. And then with joint ownership, are there different types of joint ownerships, or is that able to avoid probate?
So joint ownership is when two or more people, I'm using an example of me and my spouse, but it could be more than two people, share ownership of a property, and that will include real estate or a business or bank accounts, stocks, or whatever. So there's different types of joint ownership. Some, but not all, will avoid probate.
And what are the types of joint ownership?
Oh, okay. So the first is it's called joint tenancy with right of ownership, and so this will avoid probate, but it comes with some disadvantages. So if two or more people own property, as in joint tenants, the person who passed, the deceased owners in the property, is automatically inherited by the living owners, regardless of what you put in your will or in a living trust. So while you're alive, tax and estate planning for this would be limited. And the other owners have access to the jointly owned asset. And the property may be subject to claims of other owners' creditors.
Okay.
Right? So in my case, my brothers and I bought a little fish camp with a trailer on it, right? And so in this scenario, and it's just a small piece of land, right? But I pass under this joint tenancy with rights of ownership. It wouldn't fall to my wife. It would fall to my two brothers. And so now instead of a third, they would have 50-50.
Got it.
So after death, the property avoids probate until the death of the surviving owner. And you can't place any restrictions on survivors because they also own the property, right? So your wishes don't supersede their own. So if you don't pay attention, you could unintentionally disinherit your heirs and promise them something that you can't give. So I can't say to my son, you too shall have this fish camp, because under this rule, under this joint ownership, it didn't pass to my estate, it passed to my brothers.
Right. No, that makes sense. So, similar, with a house you own with your spouse, if I were to pass, my husband would retain the ownership.
Yep, exactly.
And then what's next on the joint ownership?
This is an outdated one, but they're still around. It's called tenancy by the entirety. And that's a type of joint ownership that exists in some states. And what that does is it provides a right of survivorship. It's only available to a husband and wife. And the advantage to this is it protects your residents from the claims of either the house or wife's creditors, but not a joint. Because if it was a joint, then you assume that obligation as well. So, but if your spouse passes and she had some debts, it provides protection in that scenario.
Got it. So in the same scenario where my spouse and I have a home, people he owed money to couldn't take the house because it's owned by both of us, but it could be vulnerable if we both owed money to the same creditor jointly.
Exactly right. Yep.
Okay. And then two left.
Yeah, okay. A third type of joint ownership is called tenants in common. And this is when two or more people own property as tenants in common. The ownership, when you pass, is not automatically inherited by the other owners. So in this case, my brothers wouldn't go from 33% to 50%. They'd stay at their 33%, and my 33% would be included in my estate value, and that would be distributed accordingly.
Got it. And then what would be the last type?
And the last type is joint ownership in community property. So there's a bunch of states with community property laws: Arizona, California, Idaho, I think Louisiana, out west. There's also Nevada, New Mexico, Texas, Washington, Wisconsin. And that's property that's joint ownership then is property acquired by either spouse or both spouses during a marriage, is presumed to be community property, right? Unless you acquired it separate from that, either by a gift or inheritance, right? So if my parents passed and they gave something to me as part of my inheritance, that would not be considered joint property. But if my wife and I said, well, we really like this piece of art and we bought that piece of art, then that would become joint property. So the deceased spouse, when they pass, there's a 50% interest in community property, right? Because it's joint between the two, is included in their estate, and it's distributed accordingly. So it's just when we were running through all that calculation, right? The community property, they're going to go, okay, the spouse passes, you take away the gift or inheritance, and everything else that's in the estate, boom, 50% goes to one spouse, is considered the estate, and then 50% it goes to the other. So, and the thing is that we'll retain that status even if the couple moves to a non-community property state. So once you start community property, you stay community property.
Interesting. And what you said earlier is that property that is transferred to a spouse as part of the estate is generally not subject to taxes?
Correct.
Okay, so I know we're nearing the end of our time here, but there's one last topic I wanted to cover today, and that's trusts. I've heard about them a bit, but the concept's a little confusing.
Okay, so let's start by defining it, right? So a trust is a legal entity, right?
Mm-hmm.
So a will is a legal document. A trust is a legal entity, and so it's more powerful. So it can be created to hold titles to assets. It can manage assets. It can distribute assets according to specific terms and conditions that you set up when you establish the trust. A trust is created by a grantor. It also could be called a trustor or settlor, and they name the trustees and beneficiaries, and they transfer assets to a property to the trust. So if I take my assets and I create a trust, then all my assets are now residing inside the trust, and the trust can manage them. The trust can distribute them.
Okay.
Right?
Trusts are created by grantors.
Right. And then there's the trustees and beneficiaries. So a trustee is one or more parties, right, that hold titles to the trust asset and administer the trust according to the terms and conditions. So somebody's got to run the railroad, right? Mm-hmm. And then beneficiaries, on the other hand, are one or more parties that receive the benefits of the trust, right? So income, assets. And that's according to the terms of the trust. So if I create a trust, and so I could be a trustee, my wife could be a trustee, but our children would be the beneficiaries. And so the trust, they'd be trust fund babies, right? So now they have a trust. They don't control the money, but the money is available to them according to the terms of the trust.
Okay. So the grantor creates the trust, then names someone to manage the trust, and that person is the trustee. And then anyone who gets something from the trust is a beneficiary.
You got it, right? And the grantor also creates the trust agreement, which is, again, a written legal document that will specify the parties and the terms of the trust.
And what are the benefits of setting a trust up?
Well, first and foremost, a trust is private, so it avoids the publicity that comes with probate, right? Mm. And so people don't get to look inside of a trust, right? Mm-hmm. If you're not a beneficiary, you won't know what is coming out of the trust, or if you're not a trustee. So it allows the grantor and trustee to isolate and transfer assets, even if there's a contested will. A trust can protect assets from creditors. A trust can protect your assets from lawsuits. And if you have a large enough estate, it can simplify the distribution of certain assets. Like if you bought a summer house in a different state, so your trust can simplify that.
So that sounds like a good thing.
Sure, right, and it's more enduring, right? A will is a document that provides directions for probate in the court, but you set up a trust, and because you have somebody that is running it, they can manage the assets for a beneficiary. So if you have a minor or someone who is not able to handle financial responsibility yet, you can delay transferring ownership or assets until a time or event is met. Or, you can make it age specific, or after you get married, and then or you can limit the transfer responsibility of managing the assets from the grantor to the trust if you got incapacitated. So you can sit there and say, hey, this is my trust, blah, blah, blah. Then you get incapacitated and they say, okay, he's no longer able to do it. And then now you have a fallback plan and your trust takes care of the issues. And because you provided the directions, the trust will execute in accordance with your guidance.
Yeah, that makes sense. And, I think we've all seen in movies and TV the kid who doesn't get,
Right.
the trust fund money until
Yep.
he's 18 or,
Mhm.
whatever. So it allows you to create those limitations.
Right.
Are there different types of trusts?
Yeah, there's a few. I'll just go real quick on them. So there's something called Testamentary Trust that's created by your will. It will be funded by your estate and it'll be administered by a trustee you name in your will. They don't become active until you pass away. So you'll own and manage your assets during your lifetime.
Sounds simple enough.
Next is more common, and it would be a living trust. And this is a type of trust that sets up and takes effect, boing, while you're still living. Surprise. So you may serve as your own trustee. You can name someone else as a trustee. And when designed properly, the trust assets may be distributed directly, or they could be held for the benefit of your beneficiaries upon your death to avoid probate.
Okay, so basically you just move your assets into a trust to avoid probate.
Right. And so that, right, so now you're avoiding probate and you're getting privacy, but we can't make it that simple because there's different types of living trusts.
Of course.
So you can have a revocable or an irrevocable living trust. So a revocable trust allows the grantor to revoke the trust or modify its terms at any time. So I can transfer assets in and out of the trust without limits, but assets will be taxed as part of the estate. A revocable trust avoids probate, and it can be used to hold assets in multiple states to avoid multiple probates, right? So you don't. So this is saving you some time. The grantor can make changes to terms and trustees and beneficiaries at any time. And if the grantor changes their mind or if there's legislative changes that would affect the trust assets, you have the ability to react and modify the trust in response to those.
Okay. And what are the trust assets?
The grantor it essentially gives ownership of all your assets to the trust.
Okay.
So when setting it up, they would be transferred to the name of the trust, right? And so that would be a title transfer, revised deeds for real estate, and then a pour over will, if you will serve to transfer any assets outside of the trust at the time of death into the trust.
Interesting.
Okay, so revocable sounds like, hey, things change, you want to react to those changes, so you have the chance to redo your terms, right? And the irrevocable trust cannot be revoked or modified by the grantor. You're surrendering control of the trust and the assets at the time the trust is created. And these are used to minimize or avoid income and estate taxes.
Makes sense. So it's sort of like whatever the situation calls for, that's what you would go for.
Right. So like a common irrevocable trust would be a charitable reminder trust or a life insurance trust or something like that.
Gotcha. And then what's a charitable remainder trust? What's that?
If it can be used to provide a gift to a charity, right? Hence the name, right, of your choice, and generate a source of income for you or your beneficiary. You'll get access to a charitable income tax deduction, which would be based on the estimated value of the assets expected to pass the charity upon your death, right?
Mm-hmm.
And that would be available for you in the year you set it up in the trust and contribute assets to it. But upon you or your beneficiary's death, all the assets in the trust are transferred to the charity that you've selected.
Okay.
And then the value of that trust is excluded from your estate. And if assets in the trust are sold, there's no capital gains assigned to you because the trust itself is tax exempt. So, you can say to a charity, I'm creating this charitable remainder trust. I get the benefit of it while I'm alive, but once I pass, it becomes the charity's asset at that time.
That makes sense to people to take advantage of those.
Sure, it's a good way to give back after you're gone.
And what's a life insurance trust?
So a life insurance trust is also set up during your lifetime. It's also used to avoid probate, and it can shelter life insurance benefits from potential estate taxes. Like I said, we mentioned earlier about being the owner. So the grantor gives up rights to their assets to revoke or change the terms of a trust, and they give up the right to change beneficiaries. So if the trust purchases the life insurance policy, protection from the estate tax may be immediate. But if you transfer an existing policy to the trust, insurance proceeds can be subject to estate taxes if you die within 3 years of the transfer, right? So when we're talking about, we mentioned this earlier. Hey, I had a bad visit with a doctor. I know things are going to happen, and so there's a look back associated with some of these things. And so if you had it as part of your plan and you had your spouse had ownership or you had it in your trust, they're not going to look askance at it. But if all of a sudden, you're changing everything and then you die within 6 months, they're saying clearly these actions were taken to avoid taxes as opposed to the execution of a planned estate plan, the result of estate planning. So, but if the trust owns the life insurance policy and it's more than 3 years from a transferred one, then the death benefits would be paid to the trust, and these would avoid probate and any claims by creditors. So, the trust is giving you some protection there.
So the beneficiaries of the trust can get access to the death benefits paid to the trust.
Right, because they're the money went to the trust and they're the beneficiaries of the trust. And the nice thing about that is the money is used immediately. So you have it immediately available for burial and funeral costs. And, we mentioned 9 months. So the tax bill comes in 9 months, you have assets available to you because you don't have that 6 months to 2 years on probate.
Right.
You have it, so you can, your executor will be able to say, hey, and the trustee will be able to say, okay, here's the bills, here's this, and then it'll all be worked.
There we go. So as we're wrapping up today, how would you summarize into kind of like your few takeaways?
Well, like I started, it all comes down to having a plan, right? And if part of this plan, it all comes down to your paperwork, right? You need to document and understand where you need to document your wishes. You have to understand where your documentation is. So documentation is the most important thing you can do while you're alive to plan for what will happen when you're gone. So, making sure your paperwork is in order is not something that you can do on your own, right? You should be coordinating with your spouse. As we mentioned, you should be coordinating with your beneficiaries. You should understand that people agree to your wishes, right? You're going to want to consult with an attorney, an experienced one, and to lower your costs, you want to prepare for the meeting. You don't want to have a conversation and make a lawyer explain to you at $100 an hour, this is the paperwork you should have brought, right?
Yep.
You want to show up with everything. You want to be prepared for the meeting. You want to have a list of your assets, a list of your accounts, the beneficiaries you want, items that you want to pass to a specific person. You should understand what you want to do with your medical wishes, who you trust to take care of your affairs if you're incapacitated. I often say life's a journey, not the destination, but the destination is part of the journey, right? So as hard as it is to think about the end, right? Think about, do you want to be buried? Do you want to be cremated? Where do you want to be laid to rest, right? Do you need to have a plot? Are you going to use a VA? Are you going to try to go to Arlington? Are you going to go to your home state? Everything you document now will make it easier for those who you leave behind, right? And once it's all written out and everybody understands it, you can take it to an attorney and then you make it legally binding, and then all you need to do is review it at qualifying life events.
Proper estate planning involves foresight and attention to detail. While the word estate may imply that it only applies to those with a considerable amount of wealth, as we've talked about today, this really isn't the case. Estate planning is critical to ensure your loved ones are taken care of and your wishes are carried out as smoothly as possible. Plan now so that you can relax in the future. Thank you all for listening, and thank you to our guest, Retired Rear Admiral Brian Luther. This episode wraps up Season 1 of Mutually Speaking, but stay tuned for information about Season 2 coming soon. Visit info.navymutual.org/mutually speaking to access resources and information related to this episode or submit a question to podcast@navymutual.org.